Proverbs 21:15 says, "When justice is done, it brings joy to the righteous, but terror to the evildoers." That is the standard. The righteous should have nothing to fear from their government. People doing right should be able to live freely. It is the evildoer who should fear legitimate authority. Hold that verse in mind as we go through this today, because by the end of it, you'll understand exactly how far we've drifted from that standard. September 11th, 2001, 19 terrorists, 3,000 Americans dead. A nation in shock, in grief, and in fear. And 45 days later, 45 days, Congress passed a 1,000-page piece of legislation that almost nobody read. The USA Patriot Act. It passed 98-1 in the Senate. 98-1. Signed immediately. Government promised the powers were limited, targeted, temporary, and necessary. They promised oversight. They promised safeguards. They promised these tools would be aimed at terrorists. 24 and a half years later, we can evaluate those promises, and the verdict is not good. Today, I'm going to lay out what the Patriot Act actually authorized, how those powers expanded far beyond terrorism, how they were weaponized against ordinary Americans, and what accountability and reform actually require. Both parties built this system. Both parties need to answer for it. Let's get into it.
The independent media company, The Truth in the Darkness Network, presents the Courage in the Darkness show with your host, Philip Roberts, shutting down the narrative and bringing you the truth that the indoctrinated leftist sheep can't handle.
Most Americans know the Patriot Act as a vague post-9/11 security law. Most do not know what it specifically authorized. Let me put the specifics on the table. Section 215 allowed the FBI to demand any tangible records from any business relevant to a terrorism investigation without probable cause and without identifying a specific suspect. It just had to be labeled relevant to terrorism. This provision was used to justify the NSA's bulk collection of phone metadata on every single American. Not suspected terrorists, every American. Who you called, when you called, how long you talked, all of it collected and stored by the federal government without a warrant. Verizon, AT&T, Sprint, all compelled to hand over customer data. The entire architecture of mass surveillance in this country runs through that single provision. Section 213 authorized what are called sneak and peek warrants. The government can search your home or office and not tell you about it for weeks or months. They can enter your property in secret, search it, and delay notifying you until they decide the time is right. Government justified this for terrorism cases. In practice, according to government's own reports, the overwhelming majority of sneak and peek warrants have been used for ordinary drug cases, not terrorism. Section 505 is perhaps the most troubling. National security letters. These are administrative subpoenas issued by the FBI with no judicial oversight whatsoever. An FBI agent, not a judge, can demand your phone records, financial reports, or internet records, and the recipient is under a gag order that prevents them from telling anyone it happened. No judge reviews it, no court approves it. The constitutional requirement of judicial oversight is bypassed entirely. NSLs have been issued hundreds of thousands of times, mostly not for terrorism. And then there's the Foreign Intelligence Surveillance Court, FISA, which the Patriot Act expanded significantly. FISA is a secret court. Proceedings are classified. There's no adversarial process, no defense attorney, and the court approves more than 99% of government requests. It's not meaningful oversight. It's a rubber stamp with a rope. And as we will get to, it has been used for purposes that have nothing to do with foreign intelligence or terrorism. Government promised these were temporary emergency powers with sunset clauses that would require renewal and rejustification. The Patriot Act has been renewed repeatedly, expanded, and is embedded in the permanent infrastructure of American law enforcement and intelligence. The emergency never ended because emergencies are useful. The NSA's bulk phone metadata program is the most documented abuse, exposed primarily by Edward Snowden in 2013. The scope of what Snowden revealed was staggering. NSA was not collecting phone records on suspected terrorists. It was collecting phone records on every American simultaneously. Additionally, the PRISM program gave NSA access to communications data directly from Google, Facebook, Microsoft, Apple, and Yahoo. And upstream collection tapped the physical internet backbone itself, intercepting data traffic at the nodes where internet communication travels. This is not a targeted surveillance of suspected criminals. This is a surveillance state. But the mass collection is only part of the story. The other part is how these tools were turned on Americans who had nothing to do with terrorism. In 2013 and 2014, the FBI was found to have improperly used national security letter authorities hundreds of times, accessing records it was not authorized to access, retaining data it was required to purge, and conducting surveillance that exceeded what the law permitted. The Inspector General documented this. Nobody went to prison. The FISA court became the vehicle for political surveillance in the most consequential domestic scandal of recent years. The Carter Page FISA warrant, obtained by the FBI to surveil a member of the Trump campaign, was built on the Steele dossier, which the FBI knew at the time was unverified political opposition research funded by the Clinton campaign. The Inspector General found 17 significant errors and omissions in the FISA applications. Agents withheld evidence that would have undermined the warrant request. The FISA court was deceived, and the surveillance of an American citizen was obtained through fraudulent applications to a secret court with no mechanism for accountability. One FBI attorney was convicted for falsifying evidence. Nobody at the senior level was prosecuted. The FBI also opened investigations into parents who appeared at school board meetings following a letter from the National School Boards Association that described parental protest as potential domestic terrorism. Internal FBI documents showed threat tags applied to parents exercising their First Amendment rights at public meetings about their children's education. These are not hypothetical abuse scenarios. They are documented. The Fourth Amendment is not ambiguous. It requires warrants issued by judges based on probable cause, describing specifically what is to be searched or seized. Mass data collection without warrants, secret administrative subpoenas with no judicial oversight, and surveillance applications built on fraudulent evidence are not edge cases around the Fourth Amendment. They are violations of it. The question is not whether these abuses happened. They're in the Inspector General reports. The question is whether the American people are willing to demand that the constitutional standard actually means something. Supporters of mass surveillance make one primary argument: it keeps us safe. The claim is that collecting everything means you can find the needle in the haystack when you need it. Bulk collection allows pattern analysis. Mass surveillance prevents attacks. Here's the problem with that argument. The record does not support it. The Boston Marathon bombers were known to the FBI prior to the attack. Russia had warned U.S. intelligence about Tamerlan Tsarnaev. The San Bernardino shooter had been reported by neighbors. The Orlando Pulse shooter had been investigated twice by the FBI. In every one of these cases, the surveillance apparatus had information and failed to act on it. The haystack did not help find the needle. It obscured it. The Privacy and Civil Liberties Oversight Board, a bipartisan federal oversight body, evaluated the Section 215 bulk phone records program in 2014 and concluded that it had not been essential to preventing any terrorist attack and that any useful information obtained through it could have been gathered through targeted, warrant-based surveillance of actual suspects. The bulk collection was not necessary for the security benefit that was claimed. The choice being presented to Americans, safety versus liberty, is a false choice. Targeted surveillance of actual suspects based on probable cause, approved by judges, subject to adversarial process, is both more constitutional and more operationally effective than mass collection that buries analysts in irrelevant data while actually motivated terrorists conduct their planning in the gaps. The Fourth Amendment is not an obstacle to security. It is a framework that makes legitimate targeted surveillance more credible, more legally durable, and more practically effective. The honest conversation about reform has to begin with a principle. These tools belong to whoever holds power. The surveillance infrastructure built under the banner of stopping terrorism is the same infrastructure used to investigate parents, political campaigns, journalists, and religious communities. It doesn't matter which party built it. What matters is that it exists, that it's unchecked, and that whoever controls the executive branch controls it. If you would not want your political opponents running this system against you, and you should not, then the system needs constitutional limits that apply regardless of whoever is in power. Several concrete changes are both legally achievable and constitutionally required. National security letters must end. They are warrants without judges and have no constitutional basis. Every demand for private records must go through a judge based on probable cause with a specific target identified. No exceptions. The FISA court needs genuine adversarial process. A cleared defense side advocate must be present for every significant surveillance application. Applications must be reviewed for material accuracy before approval. The 9% of rejected applications in FISA history represents the entire record of adversarial pushback the court has ever had. That's not oversight. That is institutional capture. The bulk collection under Section 215 must be prohibited. Targeted collection on specific suspects with warrants is the constitutional standard. Collecting the communications of every American on the premise that some of it might be useful is not targeted collection. It's a fishing expedition at a national scale. Every surveillance authority currently in statute should carry a sunset provision that requires affirmative congressional reauthorization on a defined schedule. Permanent emergency powers are not emergency powers. They're permanent powers. Force Congress to justify them on record, repeatedly, in public. And accountability for documented abuse has to be more than one FBI attorney taking a plea. Officials who obtained FISA warrants through fraudulent applications, who exceeded NSL authorities, who applied domestic terrorist designations to parents at school board meetings. They need to face consequences that reflect the seriousness of using the government's most powerful surveillance tools against American citizens without legal basis. Back to Proverbs. When justice is done, it brings joy to the righteous and terror to evildoers. The surveillance state we built after September 11th has inverted that. Parents exercising their constitutional rights at school board meetings were tagged as domestic terror threats. A presidential campaign was surveilled based on fabricated evidence submitted to a secret court. American citizens' phone records were collected without any suspicion of wrongdoing. The righteous are not living in joy. They're living under suspicion. And the evildoers? The Boston bombers proceeded. The San Bernardino shooters proceeded. The surveillance apparatus had information and failed to use it. Mass collection of everyone's data did not stop them. It just ensured everyone else was watched in the process. This country was founded on the principle that government power requires limits. That those limits are written in law. And that when government exceeds them, the people have the right and the responsibility to demand accountability. The Fourth Amendment is one of those limits. It's not a technicality. It's a statement about the kind of country this is supposed to be. One where the government has to justify its intrusions into the lives of its citizens before a neutral judge with specific cause in a process that can be challenged and reviewed. We traded that standard for mass surveillance in a moment of fear. It's past time to take it back. Support this network's continued work at titdusa.com and the Stand Against the Silence campaign. Stand with us, support the mission, refuse the silence. I'll see you next time. God bless you guys.